24 and 25.
Okay, this item come up on Monday.
Monday. This is for admission. Or for hearing. Yes. The learned counsel at 24, 25. The learned counsel, Mr. Swayams, appearing for the petition. You are for a respondent,
Okay, for the steps from
state respondent. Appearing for a state respondent submits a praise for an adjournment. I have also heard MS appearing for the petitioner. The prayer for adjournment is allowed. List on 25. Monday 25.
yes,
25. Huh?
25
25.
published.
Mr. Bachi,
Yes.
to mention item number 26 of the reading about you.
Yes.
I need bring us 2 weeks time since my seniors at this course.
That's it. Your senior is L. Longkumar.
Yes, about you.
The learned counsel MS
QBN
appearing for the petitioner submits that the learned conducting counsel, Mr. N. Longkumar, is indisposed today and on that ground an adjournment has been prayed for. I have also heard the learned counsel for a state respondent. The hearing is adjourned accordingly. List after 2 weeks for hearing. Yes, yes.
So I think to mention item number 3 on behalf of AIO.
Item number 2.
Better after 3 weeks.
3 is which, 3. What's the
No,
one?
I
3?
think item 3.
Oh, it's- You're for a state respondent.
Not simple.
The learned counsel MS so and so, appearing for the state respondent, raised for an adjournment. Who is for the petitioner? Petitioner is absent. Uh, Accordingly, the matter stands adjourned accordingly. The matter stands adjourned accordingly. When do you want it?
After 3 weeks.
Least after 3 weeks.
Similar to with item 5 and 6.
5 and 6.
Sorry.
5 is tag do it 4.
4, 5 and 6 version
4, 5
and 6 version.
and 6. Same order.
Lordship, item number 8. On behalf of AIB,
Hmm.
and for 2 weeks time.
The item number 8.
Lordship,
The learned counsel MS so and so. Appearing for the respondent prays for an adjournment. You are for the petitioner. I have also heard Mr. So and so appearing for the petitioner. The hearing is adjourned accordingly. Oh, the matter is adjourned accordingly. When do you want it?
for 2 weeks. Lordship.
After 2 weeks. Least after 2 weeks.
Lordship, similar prayer with item number 10.
Hmm.
Lordship, I also have the connection, carry item number 17, 18, 19.
Item number 10. 10 also same. I have also heard Mr. You are for the petitioner. So and so appearing for the petitioner. The matter stands adjourned accordingly. Least after 3 weeks.
Lordship,
Then
Lordship, also hearing item number 17, 18, 19. On behalf of Inahori. Now, is this better after 3 weeks?
on the request of MS so and so, the United States respondent. The matter is adjourned today. I have also heard MS
Mr. Chairman.
appearing for the petitioner. Least after 3 weeks for hearing.
Lordship, similar prayer with item number 21.
21.
On behalf of Inahori.
21. Same order. Heard MS for the petitioners to counsel MS so and so. The matter is adjourned accordingly.
Lordship, item number 26. On behalf of HM. Pending for 2 weeks time.
2 weeks.
Lordship.
26.
Lordship.
26 is already adjourned. Already adjourned. Already.
Then item number 27. On
26.
behalf of Busy Money. When is this better after 3 weeks?
And then in this matter, you are petitioner.
27 lordship.
But in this matter, you are petitioner. You are appearing for Z. Jimoni.
Lordship.
He is the counsel for the petitioner. MS so and so.
B is moving lordship.
Oh. What a respondent.
Lordship.
You are not appearing on behalf of Z. Jimoni.
B is moving lordship.
You are for Z.
I'm
Jimoni.
from Z.
You are for?
Z.
You are for a state respondent.
Lordship.
The learned counsel MS so and so appearing for the state respondent praise for an adjournment. I have also heard Mr.
It was.
Appearing for the petitioner. The hearing is adjourned accordingly. List after
3 weeks.
3 weeks.
Lordship, I also like to make a mention either over TV line on behalf of AI way. 3 weeks time lordship.
Same order. I have also heard Mr. What is your name? Your name? Appearing for the petitioner. The list after 3 weeks.
Lordship, item work 30 and 31. Kindly grant 3 weeks time.
The learning counsel MS so and so appearing for the state respondent praise for an adjournment. I have also heard MS appearing for the petitioner. The hearing is adjourned accordingly. List after 3 weeks for hearing.
I will pledge.
Yes.
Lordship, I beg to mention item number 40. Lordship, I'm very for my senior, you know, what he responded to. I made it, if this matter would be adjourned for 3 more weeks, as we are yet to file our opinion.
For the CGC, CGSC.
Yes, Lord. CGC.
The learned counsel, Mr.
Chinam Home.
Appearing for the state CGSC praise for adjournment. Who is for the petitioner? You are for the petitioner.
Yes, Lordship, I am for the.
You are Mr. Santenga.
Yes, Lordship. I'm for the.
I have also heard the learned counsel, Mr. Santenga. Do you have any objection?
Lordship, I have no objection. However, Lordship, the interim order,
Hmm.
if it can be passed until further orders.
What type of interim order? On the next date, it will be considered.
Lordship, no interim has already been considered. It has been made, it has been extended, Lordship, till the next reasonable date, Lordship.
Or then it will be extended.
Lordship.
The hearing is adjourned accordingly. List after 3 weeks. The interim order passed earlier will continue until then.
Well, very much obliged.
Next, Lordship.
Yes.
Lordship, I beg to mention item 9.
Hmm.
Lordship, I received the state of the government, Lordship.
Hmm.
Maybe about 3 weeks time to file my reply, Lordship.
Okay. There was a PB Paul.
Lordship, I want to forsake law.
The learned counsel, Mr. Joseko
So, okay.
Pote, appearing for the petitioner submits that he wants to file a reply in respect of the affidavit in opposition filed by the state respondents. Therefore, the learned counsel prays for some time. I have heard MS
Yes, Mary.
appearing for the state respondents. The prayer of the learned counsel for the petitioner is allowed. When he will file,
Lordship, 3 weeks, Lordship.
least after 3 weeks.
Lordship, calculate.
The interim order passed will continue until then. Yes,
I think to mention item 7
yes,
on behalf of the state respondents.
Yes.
I am praying for 3 weeks time. To file my review.
or you have not filed yet.
I'm preparing for respondent one to the interim order. I'm
One
going to file.
You have already filed.
It's an appendix.
You are Mr. Chubai Inchen.
I'm LD Samtam.
Oh, LD
I am
Samtam.
Cynthia Malo.
Okay. The learned counsel LD Samtam. Appearing for the state respondent prays for some time to file the affidavit in opposition. Mr. Santingar, the learned counsel for the respondent number 1, 2, and 3 has submitted that he has already filed the affidavit in opposition. I have heard Mr. Appearing for the petitioner. The prayer of the learned counsel for the state respondent is allowed. List after 3 weeks.
Yes.
Mr. Lordship.
Yes.
Lordship, I did mention item number 2. Lordship, in the previous occasion, I sought time to file my affidavit in reply.
Hmm.
However, the affidavit is ready, however, I couldn't obtain the signature of my client. So allow me to file during the course of the day.
The learned counsel MS
Kohima.
appearing for the petitioner submits that she has already prepared the affidavit in reply, but the petitioner is yet to file, yet to put signature thereon. Therefore, the learned counsel prays for some time for filing.
Lordship.
Hmm.
Readings are completed, so if a short reading will be fixed for admission hearing.
Okay. For time. I have also heard Mr. Santingar appearing for
Respondents 1, 2, and 3.
respondents 1, 2, and 3. And you are for state respondents. But the learned, you are additional advocate general. Learned advocate, additional advocate general, Mr. So-and-so, appearing for the state respondents. The prayer of the petitioner is allowed. List on 25, next Monday. Is it okay for you? List on 28th November for admission hearing.
Please, your lordship.
Yes.
Lordship, I'd like to mention hearing item 20. I for the private respondent number 5, lordship.
Item number
20, lordship.
20.
Lordship, if this matter can come up after 3 weeks, lordship.
Okay. You are for the private respondent.
Private respondent number 5,
The learned counsel, Mr.
being for that,
Appearing for the private respondent number 5,
lordship.
praised for an adjournment. I have also heard Mr. Appearing for the petitioner. The prayer for adjournment is allowed. List after
3 weeks.
3 weeks.
Lordship, there's an interim
The interim order pastoral will continue until then.
in below.
And Mr. Lordship, item 30.
1, 3.
Police. And by
The learned counsel, Mr.
That's fine.
Appearing for the petitioner submits that he needs some time to file the affidavit in reply in respect of the affidavit in opposition filed by the respondents. I have heard MS appearing for the state respondents. The prayer for the petitioner is allowed. List after 3 weeks.
Please, Your Lordship,
Yes.
may I be pleased to mention item number 28 to 8, Your Lordship. Your Lordship, if the matter can come up after a week, Your Lordship.
After a week.
To 8, after a week, Your Lordship.
The learned counsel MS
Livika, Your Lordship,
appearing for the
state, Your Lordship.
state respondents, praised for an adjournment. Heard MS appearing for the petitioner. The hearing is adjourned accordingly. When do you want it?
After a week, Your Lordship.
Least next week. The interim order pastoral will continue until then.
Your Lordship, I think it will be after a week, Your Lordship, because next week I'm having some problem.
The list after a week.
Much appreciated.
For admission, item number 1.
Your Lordship, just like to mention item number 22 and 23, Your Lordship.
22 and 23.
Yes, Your Lordship. Your Lordship, here, the state is going to file additional affidavit, Your Lordship. So another 3 weeks will be granted.
22 and 23, heard MS. So
Yes.
appearing for the state respondent. The learned counsel prays for 3 weeks time to file the affidavit in opposition.
Additional affidavit.
File additional affidavit. Heard MS. appearing for the petitioner. The prayer of the state respondent is allowed, least up to 3 weeks.
For admission, item number 1.
If it can be listed on 28/11, since I've already fixed item 2 on 28. This item may also be.
I have objection here. The land, the CC, I'm going to the here, the land was allotted to me, and my order there. Number 4 has started to study the land. No, I'm the owner of the land, I have not paid in full. And the government pay has to be the land, the duty competent has to be the land. So my prayer is nothing. But if we allow, tell us this before this, basically.
But we can take up all the issues on 28th of November also. When
The question of limitation of the town project.
Limitation.
when the matter is pending before the call, how can the question of limitation come also?
I cannot take any action because of the any, yes, question. The survey was done without my knowledge. So let me,
Oh,
the survey order.
You're for the army.
I am for the army.
Did you approach the deputy commissioner?
The commissioner has already filed the affidavit.
You could probably also be filed, is it such a nice, I do not approach anyone now. It's pending to report. This matter for question. That is the problem.
Are there any other matters like this? You were telling? Some other matters?
No, Lordship, that similar matter, Lordship, but since I have already fixed another matter, Lordship, on 28th, before this honorable court, this item may also be fixed on that same day, Lordship.
Was it will be on the same day?
20?
On the same day.
No, Lordship. There is no,
For me,
since
Lordship is a manufacturer, Lordship, because limitation comes.
it's a question of 1 week, Lordship.
It is a matter of only 1 week only. Wait
Yes,
for
Lordship.
1 week.
Yes, Lordship.
Lordship, I would like to give a brief submission.
Yes.
I have gone through the affidavit of opposition submitted by the Union of India, and on the result of the petition, this matter there is a involvement of a substantial facts. So unless it is sent back to the civil court, the matter cannot be disposed of on a record. So my humble submission for Lordship is instead of lingering here, there is no difference at all. If
Yes.
the appropriate order is passed today also.
That
the
issue is there, Lordship. In fact, Lordship, even the respondents, the state respondents and the union, they are agitating against one another, Lordship. But Lordship, I want to have a sitting with my clients, Lordship, this Saturday, Lordship. So it will kindly be listed on 28th, Lordship. Yes, I want to give them certain advice, Lordship, to advice. After going through the affidavits received from the union as well as the state respondents.
I have seen final word like 2 months back.
I would
Let
give
this Lordship, I am in operation of the land. I am in operation of the land. Survey was conducted without my knowledge. I should be informed.
who conducted the
Survey
survey?
was not
The deputy
conducted, the
commissioner.
survey was conducted by the state.
LRS.
Yes.
Then. So I was not informed. Without my knowledge, survey was conducted. I have no knowledge.
Which is why I'm saying even the respondents, they are agitating against one another.
And because of this pending case before the Supreme Court. I
Who-
believe for that.
When the land was allotted to army?
There was no particular allotment, Lordship.
Okay, wait 1 week.
Yes,
You
Lordship.
have a meeting there.
Yes, my
Because
lord.
there are some other problems.
Yes, Lordship. I understand, Lordship. Yes.
The learned counsel, Mr. Santiniega. Santianger,
Yes.
Santianger praised for an adjournment. Your CGC, The learned CGC, Mr.
Your Honor,
has objected to this matter, this prayer. I have also heard the learned Advocate General, Additional Advocate General, Mr. AP for the state respondents. After hearing both sides, the prayer for adjournment is allowed. List again on 28th November.
My lord.
sir, is there a- to dispose of on the next day?
An endeavor shall be made to dispose of the matter on the next date.
Lordship, there is an injury, the kindly continue to the next day.
The interim order, if there be any, shall continue until then.
Much obliged.
Item number 11 and 12.
Yes.
Lordship, I'm entering for respondent number one. Your Lordship, I pay for 4 weeks time to file the affidavit in opposition.
We have not yet filed.
Not yet.
You are for Union of India.
Yes, Your Lordship. We have sent the document for approval to the ministry. And we are just waiting. So on the next date, we'll file.
My property is in state because the construction work is fully warranted situation. My second information. It's for OT garden. They are starting cutting off the road and construction is cause the uncertainty of the remaining portion. So,
But he has to file his affidavit in opposition. 3 weeks time, I'll give you.
Fine.
Okay. The, you are CGC,
Yes, Your Lordship. White paper.
the, mm, item number, yeah, item number 11, agriculture officer. Agriculture, officer,
Number 11 and respondent number 10,
10.
Lordship, and in item number.
Messrs,
12,
in item number 10, 11, it is Messrs KKB projects.
KKB Lordship,
Mm.
KKB project.
Mm,
And in item number 12 and respondent number 9.
Okay,
Same with the company.
the learned CGC, Mr.
YP Gupta.
YP Gupta, appearing for the respondent number 1, has submitted that he needs 4 weeks time to file the affidavit in opposition, as he is yet to receive necessary documents from the Ministry of Road Transport and Highways, New Delhi. MS M. Bora, appearing for the petitioner, has objected to this prayer on the ground that this matter has been pending for a long time. I have heard MS Apila Sangam, Sanctum, 10. Respondent number 10, appearing for respondent number 10.
The state is open. In the 26,
In 321,
and for 218, 336, and 236, and same.
2 to 8.
I find by.
Yeah, you're senior government advocate or additional?
I have a situation.
Additional, heard the learned additional advocate general, LG Sanctum, LT Sanctum, appearing for the respondents 2 to 8. Yeah. After hearing both sides, the prayer of the respondent number 1 is allowed. This matter after 3 weeks. Along with item number 12. This matter is fixing date is difficult. After 3 weeks, it will be listed. Yes.
Item number 15.
Yeah.
For the respondent,
Hmm.
have received additional affidavit. They, recently, so, so I.
Okay.
And for the respondents, 2, 3, 6, and 7. Now, my position, I've already sent to waiting
Hmm.
and require another 2 weeks to file the selection. However, this morning, Lordship said that all I have also been served with another additional affidavit, Lordship.
Yeah.
So perhaps in response to this also, I'll need to file another affidavit, so 2 weeks.
Okay.
2 weeks will kindly be done.
The learned additional advocate general, Mr. MT, appearing for the state respondents, has submitted that he has received a copy of the additional affidavit filed by the petitioner, and therefore he needs some time to file the affidavit in opposition. Yeah. Mr. Santinengar, the learned counsel for the
Respondents 2, 3, 6, and 7.
2, 3, 6, and 7 has submitted that he also received the additional affidavit today, and therefore he needs some time to file the affidavit in opposition. I have heard Mr.
Can you tell what,
Appearing for the
my name is sorry, let me see.
appearing for the petitioner. The prayer of the respondents is allowed. Least after
2 weeks now.
2 weeks.
My name,
Oh, the name of Mr.
it's a
Hakimu Jammu shall be shown in the cause list as the counsel representing the petitioner.
For hearing, item number 16.
Lordship, this is the current case by division bench decision of this honorable court. In fact, Lordship, there are 3 different decisions passed by the division bench of this honorable court in different cases. Some are reported judgments, some are unreported judgments. One, the most recently passed judgment was delivered on 6th of February this year.
Yes.
By the bench of Justice Rubin Sultan and Justice Puti Habo. Now, Lordship, the petitioner here was appointed as a work judge Kalasi in the year 1994, Lordship. And after serving for 35 years, because in Nagaland, Lordship, as per the service rules, a government servant cannot serve beyond 35 years. 35 years is the maximum length of service a government servant can serve the government. Now, by order dated 22/5/2019, the petitioner was released from service with effect from 31/5/2019. Now, despite having served 35 years, Lordship, his service was not regularized, and despite having many of his juniors, Lordship, being regularized and being awarded scale of pay, Lordship, I have also annexed the RTI reply, Lordship.
Yes.
There is a good number of work judge employees who were regularized, Lordship, who were all junior to him, 195.
He was not regularized.
He was not regularized.
Yes.
So, Lordship, some of these 195 regularized employees, Lordship, some were regularized the very day they were appointed, some were regularized in their service without even serving for a year, some were regularized without even serving for 10 years, Lordship. But in my case, despite having served for 35 years, Lordship, and Lordship, I am a semi-literate person. I can at least have my name in the register, Lordship. So during my service tenure, I made verbal requests to my superior officers, time and again, Lordship. And then they told me, no, your case is under consideration. Don't worry, it will be done, Lordship. But despite those empty assurances, which I believed that it would bear fruits, Lordship, but it did not, and I was made to leave empty-handed. Now, Considering that many of my co-employees, Lordship, similarly situated employees within the same department, Lordship, they were regularized, I also had a legitimate expectation that my service will be regularized, Lordship, but that was not done so. So, Lordship, representation was made to the, finally, the written representation, that is,
After retirement.
yes, after retirement. However, that has also befallen deaf ears. Lordship. It has not been considered till death. And Lordship, having no other alternative efficacious remedy, I have approached this honorable court, Lordship, because Lordship, my survival, my right to life is at stake. At the evening of my life, after I have given all my sacrifice, all my youthful years, Lordship, to an indifferent government, Lordship, I, in my old age, have to look after my health, Lordship, which I am unable to, and now there is little scope for employment due to my advanced age, Your Lordship.
Now you are not getting pension and all this.
No, nothing at all, Lordship. I need medical care and attention. I'm a senior citizen now, Lordship. These are the issues, Lordship.
Where
Which
is
is why I have not,
the other covered case?
Lordship. Now, Lordship, before referring to that, I will be allowed to place another revision decision. Marked by this on the report, Lordship. In paragraph 12 of the first division bench to Lordship. I will be allowed to read.
Yes.
12. We unequivocally of the view that the term contract appointment must be terminable at some stage in their service. But if contract appointment continue uninterrupted till the age of superannuation, and as it happened in the case at hand, the character of the appointment automatically changes, and the employee has to be treated under normal government service rules, entitling the pensioner benefits. In the instant case, the stand taken by the appealant government that the respondents were on contract service, and therefore, even if they retire on attaining the age of superannuation, they will not be entitled to pension and other retirement benefits, is unacceptable. If they are on contract service, their services would have been terminated when they are youthful, and they could have carefully employed in some other avocation. But then, after using their entire services, strength out their energy, and when they are aged, old, and infirm and incapable of functioning, allowing them to go empty-handed is an invasion of the mandate of Articles 14 and 21. Right to life has been interpreted as right to live with dignity will have no meaning. The contention of the learned counsel for the appealant are therefore rejected as untenable in law. So, Lordship, this is a 1997 decision passed by a division bench of this honorable court.
Yes.
Now, in 2009, another division bench, Lordship, which is being also referred to relied upon by the last division bench, Lordship. In writ appeal 12A of 2009, State of Nagaland versus Ramaswamy. Here also, Lordship, the single bench allowed the petition, directing the state government to recognize the employee, Lordship. The state went for appeal before the division bench. The division bench dismissed it. Now again, Lordship, in the last division bench decision that I have placed, Lordship,
Yes.
which was disposed on 6th of February this year, Lordship.
Is this similar?
Yes, all these are similar cases. Lordship, in fact, the petitioner in that third judgment that I have placed, we are working in the same department, Lordship.
Yeah.
And after working for 35 years, I was also not recognized, Lordship. despite similarly situated employees being regularized, so I have approached this honorable court. The single bench allowed Lordship my petitions. Not satisfied with the single bench decision, the state government preferred an appeal before the division bench, Lordship, which was dismissed, Lordship. Now, Lordship, to be fair, Lordship, the state government has went for appeal against the third judgment that I have placed, Lordship. However, Lordship, the Supreme Court has so far, it has been listed twice or thrice, Lordship. There is no stay, Lordship. So the division bench decision, Lordship, it is still good law. It is holding the field, Lordship. And my case is fairly covered, Lordship, by the 3 division bench decisions passed by this honorable court, Lordship. And Lordship, in that decision, another division bench decision has been discussed, Lordship. And
In this judgment.
yes. And which has been held to be per inferior, Lordship, as pet law, Lordship, by the division bench of this honorable court, Lordship. Again, Lordship, in paragraph 20, if my lord, another Supreme Court decision arising out of the state of Nagaland has been discussed, Lordship.
That's right.
That has been distinguished because I am apprehensive, Lordship, that the state government will be placing that during the arguments, Lordship. Now, why it has been distinguished is that because in that case, Lordship, which is discussed in paragraph 20 of the judgment that I have placed, the petitioner's wife, Lordship, no, the employee's wife, the employee died in harness, Lordship, without being regularized. So after a delay of 12 years, the employee's wife approached the honorable court for the first time. So the Supreme Court said that no, when the employee's wife had approached the court for the first time after 12 years, and when the employee died, he was not entitled to be regularized, being a junior employee, Lordship. Then he could not have been directed to be regularized, Lordship. Now, here is a case where I have served for 35 full years, Lordship, because beyond 35 years, I cannot, Lordship. So the question of me being junior to somebody does not arise at all, Lordship. And Lordship, to top it all, Lordship, 195 employees who were junior to me, they were regularized, Lordship. So my humble prayer before this honorable court is that, Lordship, the division bench decision, which is holding the field, that the same benefit which has been extended to the petitioner in those 3 division bench decisions may also be given to me, Lordship. And Lordship, it is a question of infringement of right to life, Lordship. In the evening of my life, in my advanced age, Lordship, I have nowhere to go, Lordship. There are so many other decisions also, Lordship. In fact, in 2019, a 3 judges bench decision of the Honorable Supreme Court is there, Lordship. Friends, University State of UP, I am sure my lord is aware of that decision also. Where in paragraph 36, it has been categorically stated that when an employee has been made to serve for 30 to 35, 30, 40 years, Lordship, they must be considered as regular employees and the pensionary benefits must be given to them. Paragraph 36, actually. Now that particular paragraph 36 has also been quoted in the recent decision.
Okay.
Yes, passed by the division bench with approval, Lordship. In order not to waste my lord's time, Lordship, I may not place so many judgments, Lordship.
Yes.
Lordship, each case depends on the facts, Your Lordship, and it has to be decided depending on the facts. Your Lordship, here the petitioner is a one-charge employee. We have a scheme for absorption of one-charge employee. If Your Lordship, I can return to the scheme, Your Lordship, to page 49 of the repetition, Your Lordship. The OM
49.
49 of the repetition.
Yes.
Lordship, OM dated 17 March 2015.
Yes.
This OM covers petitioner's case, scheme for regularization and absorption of work charge and casual employees in division of pay / wages. on due consideration of the report of work charge engagement and employees commission, and in compliance with the judgment and order of our report, the governor of Nagaland is pleased to introduce the following schemes for regularization and absorption of work charge and casual employees and revision of their pay and wages, subject to conditions indicated hereunder. Regularization in service. All existing work charge and casual employees of various departments who are enjoying scale pay and who have completed 30 years or more continued service as on 1st of January 2015 will be regularized by conversion of their posts into regular ones personal to them and subject to fulfillment of conditions as indicated below. Your Lordship, the petitioner case is covered by the clause 1 of subclause 1, Your Lordship. This clause itself, Your Lordship,
Subclause?
the subclause which I read out to you, Lordship,
Ah.
all existing work charge.
Ah,
Your Lordship, the petitioner herein is on a fixed pay.
Hmm.
He has, even though he has served for 25 years,
Hmm.
he was not on scale pay, and therefore, because of that, his case could not be considered when he was serving, when he was in service. And Your Lordship, during his service time, Your Lordship, never make a representation to the department for consideration of his case. So, Your Lordship, it is a clear case that during his service life, he was not entitled as per the scheme. So, apart from the scheme, Your Lordship, where is the ground, Your Lordship, for regularization? Your Lordship,
he was on fixed pay.
he was on a fixed pay, Your Lordship. That is admitted if Your Lordship would see the synopsis. And Your Lordship, petitioner has come after the release from service has come, pray for regularization, saying that similarly situated person has been regularized. If Your Lordship would see the lease of date, he was appointed in a year 2000, in a year 1984,
Hmm.
released in a year 2019, make a representation in the year 2021. Your Lordship, this is therefore, Your Lordship, the prayer is for posthumous or false factor, ex post factor regularization. And Your Lordship, there is a Supreme Court judgment, which clearly the revision laid down in the judgment clearly covers the present case, Your Lordship. Your Lordship, I allow you to read it. It's the state of Nagaland versus Nishi actually, Your Lordship. The principle laid down, the issue laid down in this case squarely covered the present case, and this judgment is still in force, Your Lordship. It has not been overruled. Your Lordship, I'm relying around 4.1 and 4.2, Your Lordship. That is relevant.
Yes,
Very, Your Lordship.
yes.
It is required to be noted that the deceased employee died in the year 2005. During his lifetime, he never claimed any regularization. That the respondent herein, original pre-petitioner, wife of the deceased employee, claimed the regularization after a period of 12 years from the date of the deceased employee. At the time of the date of the deceased employee, he was not entitled to regularization as he was much below in the list of the work charge employees whose services were to be regularized. Under the regularization policy, the service of the work charge employees were required to be regularized as per the seniority and as and when the vacancy arises. The services of the other work charge employees, even who were senior to the deceased employees, were regularized in the year 2009, that is after the death of the deceased employee. Despite the above, the High Court has directed the state to regularize the services of the deceased employee 1 day prior to his death, which otherwise his services were not required to be regularized as his term had not come and he was much below in the seniority list. Considering the aforesaid facts and circumstances, the impugned judgment and order passed the High Court is unsustainable, then deserves to be quashed and set aside. So, Your Lordship, the ratio laid down in this case squarely covered the present case, Your Lordship.
Yes.
Lordship, I will be allowed to reply to the updates finished by my Lordship. Now, Lordship, if my Lord may kindly turn to page 14, Lordship. This is the RTI reply.
Page 40.
Yes, Lordship.
Yes.
Here, this is a list of the government employees, Lordship, work charge employees who were appointed and subsequently regularized. So, Lordship, if my lord, will kindly turn to page 41.
Yes.
From page 41 to page 45.
This is the list of employees who were regularized.
Yes, Lordship. Now, Lordship, may kindly see the columns, Lordship.
Hmm.
The last third column from the right, Lordship, date of training service.
Yes. Yes.
The petitioner here, Lordship, joined service in 1984, Lordship.
Hmm.
Now here, Lordship, 1986, 89, 86, 89, Lordship.
Yeah,
And their
no,
date of regularization is
no, no.
2016, 16,
in
Lordship.
which year you joined?
1984.
84.
Yes, Lordship. So all these 195 employees, Lordship, they are all junior degree. Now, despite that, Lordship, despite me being senior to all these employees, the regularization scheme, Lordship, that my learned finance relied upon, Lordship, it has been implemented in a pick and choose manner. Now, state being a model employer, Lordship, ought not to have acted arbitrarily, Lordship, by adopting a pick and choose policy amongst similarly situated employees. Now, as per Lordship, the Supreme Court decision rendered in Jagjit Singh's case, Lordship, that no matter in which capacity a state government employee is, be it casual, ad hoc, contingency, work charge, fixed pay, casual, all this must be given a certain scale of pay, Lordship. Even if it is the lowest scale of pay must be awarded. Now, Jagjit Singh in 2017, Lordship. I retired in 2019, Lordship. Now, if Jagjit Singh was actually implemented by the state government, Lordship, then the question of me not receiving scale of pay would not have arisen, Lordship. Now again, Lordship, in order to show that scale of pay was also, Lordship, awarded in a pick and choose manner. Lordship, may kindly turn to page 25 of my written petition.
Yes.
From page 26 to page 39, Lordship, is a list of 380 work charge employees, Lordship. If my lord may kindly refer to the columns, Lordship. So at page 26, third column from the right, date of joining service, 1988. Now all these employees, Lordship, they were granted scale of pay, Lordship. Now there is no criteria, Lordship, on how scale of pay is to be awarded, Lordship. But state, under the office memorandum that is, but state being a model employer, Lordship, or to implement this office memorandum, the scheme, Lordship, in a fair and transparent manner. That was not done, so, Lordship. And Lordship, of course, despite me making verbal requests to my superior officers, Lordship, these are, Lordship, the lowest form of public employment, Lordship. Manual works, manual laborers. So, verbal requests were made time and again, Lordship. Now, they are saying that I did not make representation while I was in service, Lordship. This honorable court has held that, Lordship, even without making representation, state being a model employer, ought to have considered the petitioner for regularization, Lordship. It is not about me making a representation or not. It is a question of whether I am entitled to it or not, Lordship. It is a question of whether state must act in a fair and transparent manner It is a question of lordship,
Hmm.
me being a victim of pick and choose policy, lordship. It is a question of lordship, me being denied of my right to life, lordship. Because lordship, right to life is not just mere animal existence, lordship. My lord is well aware that it encompasses, lordship, the right to live with dignity, the right to live with human dignity, lordship. And without any source of income, lordship, I'm living in debt and in penury, lordship, without any income to support myself and my ailing health in my advanced age, lordship. So, my lord, kindly take a passenger view, lordship. And lordship, some decisions I have also, because that division-based decision, lordship, I was the counsel in that.
Yes, yes,
Yes,
I've seen it.
yes, lordship. So there, I have relied on some cases where beneficial schemes must be liberally interpreted, so that the benefit actually reaches those people for whom that benefit is meant to be given, lordship. So I pray that the scheme may be read out, lordship, and not read down by this honorable court.
We are finding to be very high. The lordship can turn to page 3 of my country, which is paragraph 5. Paragraph 5. Paragraph 6 and 7.
Just a minute.
Yes,
You were respondent number 1.
I'm for respondent number 1, 2, 3, and 4.
Just a minute.
Yes, on behalf of respondent 1, 2, 3.
Country, yes.
For the review.
Yeah.
There are 5 here.
There are two paragraphs. Five.
Paragraph 5.
Lordship. One
Yeah, yeah.
in page 3, then the next paragraph 5 is on page 5, lordship.
There are number, there is an error. You know.
Ah, okay. I'm
It
not
should be 6 and 7 too. From
page number
page 5, page
Yeah.
number 2.
3.
Yes, your lordship.
Yes.
Paragraph 5, your lordship. That with regard to the amendment made in paragraph 4 of the petition, the deponent respectfully admits that the same to the extent of reports, it is first submitted that there are no rules or guidelines framed by the government for giving scale of pay to fixed pay employees and therefore regularization of their service. That with regard to Annex 5A annexed in the petition, the deponent submits that release of fixed pay employees who were given scale pay as per the administrative approval dated 23/7/2020. This is important. Administrative approval, on the basis of the administrative approval, those person, number into 195 has been regularized, your lordship, on administrative approval, and this was given after the petitioner was released from service. So the petitioner cannot claim, your lordship, the administrative approval retrospectively. The administrative approval is prospective in nature, confined to only this number of employees, your lordship. So, your lordship, it may be mentioned, I may be allowed to continue. It may be mentioned here in that in WP number 228K of 2018, 3 Futon K and 46 others versus the state. The Honorable Court, by an order dated 21/11/2018, directed the respondent to consider the prayer of the petitioners to pay them at a scale of pay within a period of 3 months, that the Honorable Court directions were forwarded to the government, and thereafter the government through letter number PHE so issued the administrative approval for upgradation of fixed pay to scale pay of work charge employees. As per the letter, I am directed to refer to your letter number such and such and to convey herewith the administrative approval for upgradation of fixed pay labor to scale pay in respect 31 employees who have completed 30 years or more as on first of July 2020. Further, the fixed pay employees who have retired on or before first of January 2020 shall not have the right to claim scale of pay. Your Lordship, here the administrative approval is clearly indicating that a person who has released before first of January 2020 shall not have the right. So that means the petitioner doesn't have a right, Your Lordship. Basing on the above government directive, all work charge employees who are on fixed pay and who have completed 30 years of service after first of January 2020 were given scale pay. In the present case, the petitioner was released from service by order dated 22nd of May 2019 before the administrative approval, and since the direction has specifically mentioned that the fixed pay employees who have retired on or before 1st January 2020 shall not have the right to claim scale of pay. As such, the petitioner could not be given scale of pay since the petitioner was already released from service on attaining the age of superannuation. Administrative approval is Annex A. That with regard to Annex 5B, Annex A petition, the deponent respectfully submits that the mentioned Annex are the list of employees who were regularized as per OM dated 17/3/2015. Your Lordship, I'm saying that the petitioner doesn't come within this OM, Your Lordship. It may be further stated that OM dated 23/7/2020 has specifically mentioned that all existing work charge and casual employees who are enjoying scale of pay and who have completed 30 years of continued service are eligible for regularization of the service. The present petitioner was on fixed pay till his retirement. Hence, his case is not covered by the mentioned OM. That with regard to the amendments made in paragraph 5 of the petition, the deponent respectfully stated that the respondent department functions as per the directions and guidelines issued by the state government. Accordingly, the administrative approval dated 23/7/2020, which has specifically mentioned that the fixed pay employee who has retired on or before 1st of January 2020 shall not have the right to claim scale of pay. The petitioner, having been already retired from service, could not be given scale of pay. However, work charge employees who are still on service were given scale of pay as per the direction of the government. Hence, the petitioner's statement that the department has been indifferent towards the petitioner's plight is totally false and misleading.
Yes.
My little friend from the state. A very unfortunate Lordship and most unreasonable submission Lordship. And Lordship, the communication Lordship referred to in paragraph 5, 5A, 5B Lordship by the state respondents Lordship. This is a communication between two department officers Lordship in relation to petitioners in one WBC 228K of 2018 Lordship, where the petitioners were not the party Lordship. So
Yes,
Lordship,
obviously, because he is out of service.
now Lordship, at that point of time, Lordship, I was not out of service Lordship. In 2019, I retired. This petition is dated is 228K 2018, so it was filed in 2018. I was still in service, Lordship. But Lordship, that is a correspondence, Lordship, between, it is not a notification, it is not an office memorandum, Lordship. It is not an order. Now, an office communication between two government officers, Lordship, which they have, to which I am not privy to. How can that affect me, Lordship? And my Lord is well aware that even if the Parliament, that is the Lok Sabha or the Rajya Sabha, Lordship, even if a bill is passed, Lordship, unless it is notified in the official gazette, it does not have the force of law. So how can this communication between two government officers, Lordship, affect me, Lordship? And that also, Lordship, it is not to do with me, it is to do with some petitioners, Lordship, in 228 WBC 228 K of 2018, Lordship. The name of the case, also they have stated Shri Futong K and 46 others versus the state of Nagaland, Lordship. I'm not the particular, Lordship. Secondly, Lordship, see, Lordship, my Lord is well aware that each and every case depends on the facts and circumstances of that particular case, Lordship. Now, Lordship, the case that my learned friend has relied upon, Nishibi's case, passed by the Honorable Supreme Court, Lordship. That same judge, Lordship, has passed, Lordship, if my Lord can kindly to Annexure 8, page 20
of the writ petition.
of my affidavit in reply, Lordship. Page 20, Lordship. So it's a one-page order, Lordship.
Yes,
I may be allowed to read it, Lordship.
Annexure 8.
Yes, Lordship, Annexure 8, Lordship.
Hmm.
Lordship, may I kindly see the name of the judges above, Lordship, MR Shah.
Hmm.
This is the judge, the same judge who ordered Nishibi's judgment, Lordship.
Hmm.
Now, here, Lordship, this is a case of a government employee serving for 30 years without being regularized.
Hmm.
I may be allowed to read, Lordship.
Mm.
It is unfortunate that the state continued to take the services of the respondent as an ad-hoc for 30 years, and thereafter, now to contend that as the services rendered by the respondent are ad-hoc, he is not entitled to pension/pensioner benefit. The state cannot be permitted to take the benefit of its own wrong. This is important, Lordship.
Mm.
The state cannot be permitted to take the benefit of its own wrong. To take the services continuously for 30 years and thereafter to contend that an employee who has rendered 30 years continuous service shall not be eligible for pension is nothing but unreasonable. As a welfare state, the state as such ought not to have taken such a stand. In the present case, the High Court has not committed any error in directing the state to pay pensioner benefits to the respondent who has retired after rendering more than 30 years of service.
Hmm.
Now again, Lordship, Annexure 9. This is the judgment that I am talking about, Lordship. The order. Here, in this case, I was not a party, Lordship.
Hmm.
So that communication between the two government officers, Lordship, was written in respect of the petitioners, Lordship, in this case, Lordship.
Hmm.
Your Lordship, here the petitioner is saying that he's not a party, but at the same time, he's claiming for the benefits, the Lordship. Lordship, apparently-
So my Lord is well aware when I'm not
Lordship,
a particular case, Lordship.
And your Lordship, the case which the petitioner has referred to is it's a state of Gujarat. Whereas totally we have a scheme, your Lordship. When the petitioner does not come within the scheme, where is the right, your Lordship? Where's the
Right to
of the
equality,
petitioner, your Lordship?
right to life,
And your Lordship, if
right
this-
to public employment, it is the same throughout India, Lordship.
Yeah,
We have only one constitution in India.
the apex court order still stand, it has not been overruled. And if this petition is allowed, then it will run counter to the apex court order. That's my-
And as I'm saying, Lordship, at the post of petition, Lordship, my case is well covered by the three judges, three division benches. Of this order. I'm of that.
Okay. I'll dispose of the matter today.
Keep the right.
Yes.
Chair, I have for respondent number five.
Hmm.
I'm stepping on behalf of my senior counsel.
Hmm.
The Lordship, in this, the condition and grievances raised in the present petition is between the petitioner and the staff respondent. The Office of the Accountant General has no role in regularization of service and sanctioning of pension benefits. So it is only on the receipt of the pension, the claimant's incomplete check from the pension sanction authority to to the office of the department, the role of the office of the accountant general shall come into play, Lordship. That's my submission.
For hearing, item number 32 to 34.
Yes.
Why not, here, in all with the issue, that is the case number 37, 38, and 39. The petitioners are applying for the release of the salary. Who are still working under the executive engineer under MWD.
Why their salaries are not released? Why the salaries are not released? Why?
On last occasion, the students has submitted that there are certain verifications. Your Lordship,
They,
however,
are they regular employees?
my lord,
Are they regular employees? The petitioners are regular employees.
No. There are work charge employees, Your Lordship, some of them on scale of pay and some of them fixed.
Your Lordship, however, in item number 33, which is the PPC number 38 of 2024. Your Lordship, here the petitioner has received all the salary pending salaries.
You already received
Yes, in this particular item 33.
33, so it will
Yes.
become infractious.
Your Lordship, so can you allow me to close?
You want to withdraw it.
To close the matter?
In item number 33,
Yes, ma'am.
in item number 33, the learned counsel MS, your name,
Mr. President.
Ms. Kikisino, appearing for the petitioner submits that the petitioner has already received all the salaries and emoluments for which he filed this writ petition. The learned counsel submits that the matter may be closed now. I have heard Mr. Anangami, the learned
Senior government.
senior government advocate. After hearing both sides, the present writ petition stands closed and disposed of. Item 38. 38 is gone.
33.
Now remains
30.
37 and 39.
Yes, ma'am.
Yes, Mr. Angami, what is your reply to that?
Yes. Thank you. I'll start with 30, 37. The PPC
37, yes.
Lordship, the respondent department has numerous work charge staff under the department, Your Lordship. And Your Lordship, some of them are, of course, diligently performing their duties. However, some of them, Your Lordship, without appearing to their duties, they were just drawing salary. And this has come to the knowledge of the government. And therefore, the government actually undertook screening, undertaking a screening to see which are the work charge employees who are actually performing the duties and which are not. Now, in that process, Your Lordship, the work charge employees were categorized into 3 categories. That is category A, the category R1, and category R2. Now, category A work charge employees are those employees where there are no anomalies at all. And therefore, till date, their salary has not been stopped, they are getting their salary. The petitioner hearing, in all the writ petition, Your Lordship, the petitioners fall under category R1. Now, R1 employees are those employees, Your Lordship, where in their service records, certain anomalies are there, such as the name has been wrongly listed, or the name of the father has been wrongly listed, or the date of birth, all these things. So, Your Lordship, we have taken the thing out and then we have verified it, calling upon the petitioners also to submit the necessary document. And in that process, Your Lordship, the salary of the petitioners was stopped. However, Your Lordship, we have started making the payment, Your Lordship. In fact, in my affidavit of opposition, Your Lordship, I have annexed documents where the salary of the petitioners were paid from March 2023 to February 2024. In my affidavit of opposition. Thereafter, the lordship, this was this payment is made under the division of long land PWD RMP because the petitions are under this division, your lordship. Thereafter, your lordship, by another order, 11/7/2024,
Mr. Angami,
lordship.
that procedure is still going on or it is complete?
It has completed, your lordship. Therefore, we have started making the payment. And therefore, for the petitioners therein WPC 39, all the payment has been done. For these two other petition, payment have started.
Has started.
Has started. Has started. And therefore, in that process, for the petitioners in WPC 37, from March 2023 to February 2024, we have made the payment and we have annexed it as annexures in our affidavit in opposition, your lordship. Thereafter, your lordship, by another order, 11/7/2024, your lordship, if I may be allowed to place this.
Yes.
The salary of the petitioner has further been paid up to July 2024. The name of the petitioner, your lordship will find it as serial number 7. I have marked it.
Yongta.
Yongta. It has been further paid up to July 2024.
Up to July.
2024.
July, August,
Yes.
September, October.
That is awaited, your
Only
lordship.
3 months.
Yeah, that is awaited.
So you better wait for some time. They have started to pay. The learned senior government advocate, Mr. Angami,
Lordship.
submits that the state has started to pay the salaries. The last salary paid to the present petitioner was in the month of February,
No, July.
July,
And the last paid up to July 2024.
July 2024. According to Mr. Angami, the remaining part of the salary would also be paid within a short time.
Your lordship,
Yes.
as far as that part is concerned, your lordship, what happened is, your lordship, if I may be allowed to give a short submission again, as far as the money part is concerned. Your lordship, these the work charge employees, they are paid under a different head account. Issued and the money is issued by the finance department under a different head account. And therefore, your lordship, we have already asked the money from the finance department, however, but the responding department is yet to receive the amount. And therefore, it may take some time, as per the availability of the amount.
Mr. Angami submits, last one and continue. Mr. Angami submits that the remaining area salary shall also be paid in due course of time.
Yes.
I have heard MS. Preparing for the petitioner. Since the state has started the process of paying area rents. The petitioner is advised to wait for some time. Therefore, list is made after 6 weeks. So this is item number 37, item number 32. Item number 34 also same.
Yes, your lordship, but here, your lordship, we have made the payment up to August 2024.
ইয়ার লিখব আগতে লিখেছিল তো জুলাই 2024 লিখেছিল এটা অগাস্ট 2024
Yes.
রিমেইনিং পার্ট সেম ওকে
I'm deeply obliged.
ওকে ওকে
Obliged.
आज का रिकॉर्ड डिलीवरी डिस्पोजल बहुत रिकॉर्ड आज का डिस्पोजल बहुत आज ये डिस्पोजल वाला रिकॉर्ड पड़ा फर्स्ट डिस्टो ले लेते हैं और वो चार्ज कर रेस्पॉन्डेंट नंबर 1 एडवोकेट का नाम क्या है अभी का हाँ अभी का ना जो रिजर्व हाँ लिख दीजिए दोनों रेस्पॉन्डेंट्स और एक ही से ना